Now, registration also is not required, but before you can sue someone, before you can go to court and enforce your copyright, you must register the copyright with the Copyright Office. And that's the key to the courthouse, is registration. And registration is very simple, and I'll go to the Copyright Office website now. You can get all those, download all those things from the website. It costs you $30 to register. It's really pretty simple. And the law does give some advantages to someone who in fact registers his or her copyright within 90 days of publication. So if you have anything valuable, potentially valuable, you probably should register it within 90 days of publication, because the law gives you some advantages. There's some presumptions. If you do sue, you can get statutory damages as opposed to actual damages, and some other things that only lawyers care about. But there are some advantages to registering within 90 days. But you don't have to.
Can you define statutory?
Well, I'll get to that. In other words, the statute says that if you don't want to get actual damages, the actual money that you lost, you can actually opt for a statutory amount, from $750 to like $30,000. So that's what we're talking about. I think that I talk about that later. Yeah, Roman numeral 6. It's mentioned in Roman numeral 6. So that's why most people do in fact register. Who is the owner of the copyright? Now that obviously is a big issue, particularly in a business setting or in a university setting. Now, the basic premise is that the creator, the author, whoever creates the work, the copyright vests in that person. The creator, the author, creator, whatever you want to call it. That person owns the copyright. That's through the copyright vesting. But there is a major exception under the statute, which is called a work made for hire. Okay? Now, a work made for hire under the statute is in fact possible in two ways. One is if something was created within the scope of employment. That's the most common way a work for hire is created, because someone does create something within the scope of their employment. The employer owns the copyright, not the creator, the employee. That's the most common way. And then the second way is if there is a signed agreement saying it is a work for hire. Both parties have to sign that there is an agreement that this is a work. If you're not in other words, I tell students or whatever anyway when I talk to journalists or other people about this, if they're a freelancer and you sell a magazine article to, Harper's. Is Harper still being published? I think it is. And they pay you $1,000 for it, which is fine. And so you take your $1,000, they publish it, and then you want to go and publish it somewhere else. Well, you can do that because unless you have a signed agreement, now typically most magazines would tell you, they would force you to sign a work for hire agreement. Okay, but I tell students, don't ever bring that up. If nobody brings it up, and there's no signed agreement, you still own the copyright. All that the magazine has done is given you $1,000 for a single publication right. Okay, but most publications are sophisticated enough that that's part of the boilerplate. You have to sign over your entire life. Sign that whole thing over to in fact get if they're going to pay you for it. But if there's situations where people aren't very sophisticated, I always tell people don't say a word, just take the money and run, because then you still owe, because you're not an employee. It's not a work for hire unless there is a signed agreement, because you are not an employee of the company. Okay. Now, universities have always looked at this somewhat differently. Okay. Although technically, I know that there's not any really law that says there's sort of an academic exception to this, but traditionally in academia, at least in the United States, professors have always, owned their work. Now, technically, anything I do at the university, probably in the technical sense, is a work for hire. I use university facilities. I put it on my, when I get promoted and tenure and all that sort of stuff. So, I mean, it's certainly, unless I do it all at home in my spare time or whatever, it's really a work for hire. But most universities have sort of haven't really enforced that, or just has been tradition with the faculty members. Even before, obviously, in our latest UPI contract, we have a specific language on that. But prior to that, it's interesting. The Board of Trustees regulations said that basically the work for hire applied, except for things you do on a sabbatical. So if anything you did on sabbatical was yours under the old guideline. Now, of course, under the UPI contract, the faculty member owns everything he or she does. The university has, I guess, the only thing the university has is a royalty-free license to use it. Is it for a year after a person leaves or something, or something? I can't remember exactly what it is.
Yeah, don't know the details.
Right, I think that's right. In fact, I was on the task force that worked on that. Were you on that task?
Oh, yeah.
That's where you were on that task. I remember we met every Thursday for a year, it seemed. Right, so that and some universities that's not the case, and so there's always a lot of people didn't really care about that until, I guess, some people thought there was a gold mine with online courses and all those sorts of things. That really hasn't developed and probably never will. So there was some debate about that. So obviously, from a faculty standpoint, Eastern's policy is damn good, and I was sort of surprised that the university went along with that. But I guess they decided it really wasn't probably didn't make a whole lot of difference.
Well, did they ever enforce the work for
I don't
hire
think
thing
so.
ever?
No,
So it's
not that I
not
know
really
of.
any-
But if somebody had done something that really was valuable, then we probably need to get our finger into that. I mean, but since we're not a research institution, at major research institutions where you have patents and copyrights and all sorts of things involved, really patents that hold it level with scientists and so forth. And of course with patents, patents are very difficult to create. And typically you have to have a lot of legal help, and so many research institutions have a patent office that helps faculty do this. So as part of that, they get a cut. So it's a 50-50 share or whatever it might be. But the work for hire business is real critical in all sorts of situations. Now for non-faculty who aren't part of the contract, I think work for hire certainly applies. I'm not sure that we've ever had any issues involving that, but if when you created some neat thing, piece of software to use in some office, and it had some market possibility, the university would own it, not you. So that's how long does copyright last? The duration of the copyright is the life of the author plus 70 years. If it's a work for hire, where it's not a person, then it's 95 years. Okay. Now that's an example of how the law has changed. A maximum of 28 years in 1790. In the 1909 law, it was 28 years with a 28-year renewal, a maximum of 56 years. When the 1976 law was enacted, it was life of the author plus 50. Okay. Then in 1999, Congress extended that to 70 in the Sonny Bono Copyright Extension Act of 1999. I guess I can understand why Sonny Bono would have been interested in this, but of course then he hit a tree and that could have ended all that. They know he was skiing, but anyway, they extended the law now to be cynical. In fact, really what happened there, and I'm telling you the truth here. Mickey Mouse was about to go into public domain, and Disney, used their lobbying power, one of the big pushes in extending the longer. Now, the statute, it's real complicated because when the 1976 law was passed, it said anything at that point in its first 28 years got an extra X number of years. And anything in its second 28 years got an extra number of years. And I can't remember the different things. So